Welcome to the webinar. I love that I'm hearing a few pieces of feedback on the music. I'm in the Christmas spirit, and you guys all have to pay for that. Hi, I'm Christy Sanger. I'm with AHEP, and I am excited to get us started on our December webinar. Let me get the presentation up. Click a minute. All right, so hopefully you can see me and hear me. If you can't see me, that's okay. I'm going to go away very soon, and we're going to have our actual presenters available. They're not going to be on the webcam like I am, but they'll be there, and you'll be hearing them speak instead of myself. So welcome to the December AHEP webinar. For those of you that are members, this is just one of the many webinars that you've been with us for this year. For those of you that are not members, because we did open this up to non-members fairly recently, and we just want to say welcome. And if you find this webinar helpful and useful and think you might want to attend others, please stay tuned on our website. We'd love to have you. For those of you that are logged in over the phone, please mute your phone lines. We do actually have both of our speakers that are going to be presenting through the phone line. So if we don't have you guys muted, we won't be able to hear our speakers. So if you happen to be on the phone line, make sure that you mute your phone. So with no further announcements that I need to make, I'd like to introduce our Hospital Legal Preparedness Understanding the Role of the Law When Hospitals Face Emergencies presentation. This presentation is going to be presented by two presenters. They're listed on your screen on the slide. Gregory Sunshine is a legal analyst with CDC's Public Health Law Program in the Office for State, Tribal, Local, and Territorial Support. He oversees the Disaster and Public Health Emergency Declaration Law Project, as well as a number of other public health law research topics on emergency preparedness and response. Gregory travels to health departments, teaching response personnel about the role of the law in public health. And it looks like I'm going to have to send that call. And serves on the Healthcare Preparedness Activity Closed Points of Dispensing Toolkit for Healthcare Partners Advisory Group. Gregory earned his JD with a certificate in health law from the University of Maryland School of Law and his Bachelor in Political Science from Dickinson College. For those of you that are logged in on the phone, just a reminder, please mute your phone lines because we do have to keep the phone line up because our presenters are on the phone line. So if you just logged on and haven't heard that announcement, please mute your phone line. Our second presenter is Michael Munda, and he is the Director of Accreditation and Regulatory Compliance and the Emergency Management Planner for Renown Health. He served as the incident commander for many code triages, including the Reno Air Races crash on September 16th, 2011. If you haven't heard that story, I recommend that you find somebody that can tell you about that. It was pretty incredible. He also chairs the Emergency Management Committee and is a member of the Local Emergency Planning Committee and has chaired the Inter-Hospital Coordinating Council of Northern Nevada. Renown Health is Northern Nevada's largest integrated health network, a level 2 trauma center, and a nationally recognized healthcare leader. Michael is a graduate of the University of California, Los Angeles School of Law with a master's degree in educational leadership from the University of Nevada, Reno. He's also certified professional in healthcare risk management and a certified Joint Commission professional. He has 12 years of experience in healthcare compliance, quality and risk, accreditations, operations, property, acquisitions, and emergency management planning. I am going to cut some of those introductions a little bit shorter because I want to make sure we allow the most time for our presenters to tell us their information that they have to share with us. So without further ado, I think Gregory is up first. So I will let you get started, Greg. Welcome.
Thank you very much. I'm really happy to be here, happy to participate with your organization. I'm really excited to make a new partner in our field of emergency preparedness. Thank you for the wonderful introduction. My name is Greg Sunshine. I am a legal analyst with Carter Consulting and serve CDC's Public Health Law Program. The Public Health Law Program, our mission is to advance the use of law as a public health tool. We do that through a few different methods. We create tools that can be used to influence public health outcomes. So we provide legal epidemiology to state, tribal, local, and territorial health departments and their partners. And this includes legal mapping and legal evaluations. We also provide legal guidance for research. So that includes memos, literature reviews, resource navigation, and peer review. And then we also serve a role in research innovation, so conducting methodology reviews, logic modeling, provide funding, and also do translational work. So we really, one of our big tools that we like to provide is training and workforce development. So this includes webinars like the one you are on right now, but also in-person trainings and providing public use training materials that anyone can download and use for their own purposes. We also provide fellowships and internships and externships for new attorneys or students who are in law school or in public health school who are interested in learning more about the role of law in protecting the public's health. Our primary audience is state, tribal, local, and territorial health departments, but since there is a very specific interaction that happens between those health departments and private health care, we try to touch on those topics as much as possible, hence this presentation. So if you want more information, you can visit this short little URL down at the bottom of the slide. I've also included 2 URLs on the side. One of them is to our Public Health Law News, which is a really great resource, monthly and bi-monthly email that goes out providing the latest in public health law news and other trainings that can be available, so other webinars. And it's not just preparedness. We touch on a lot of other topics like prescription drug overdose, health systems transformation, electronic health information, and tribal public health law as well. So please feel free to visit either of those links to see some more. Before I get started, I am an attorney, and of course we have to provide a disclaimer because we love disclaimers. They're wonderful little things. But really this disclaimer is just to say that the contents of this presentation haven't been formally disseminated by the CDC and shouldn't be construed to represent any agency policy or determination, and that the legal advice that I'm going to be presenting today is for instructional use only and is not meant as a substitute for professional legal advice. So if you are a non-lawyer on the webinar and you are in need of legal advice, please contact a qualified attorney in your jurisdiction. So throughout this presentation, my goal is for the first 2 bullets. I want to kind of show you why legal preparedness is important, why it's important to understand the law, the role that law plays when it comes to preparing for emergencies. And then I'm going to tell you a little bit about the intersection of public health authorities and healthcare. And then Michael's going to come on and tell you about defensible emergency management programs in healthcare. So to start off, why prepare when it comes to legal issues in emergencies? Well, we have a lot of really good reasons. And there are a few recent cases that demonstrate that failure to prepare for a foreseeable public health threat or emergency can result in allegations of liability. And those can come from both the patients and the public, as well as employees of the healthcare facility. So here's an example of a possible source of an allegation that you didn't properly plan for emergency that can come from members of the public. Now, these 3 cases that you can see right here are all 3 fairly similar lawsuits that were filed by a disability rights advocacy group against government agencies, the agencies that were charged with preparing for emergencies. But as you know, the ADA applies to anyone that is serving the public. So you have to provide reasonable accommodations for persons with disabilities Otherwise, it can be seen as discriminatory. In these lawsuits, the first bullet, communities actively living independent and free versus the City of Los Angeles, a judge held that the city had violated both the state disability protection statutes and the Americans with Disabilities Act because they didn't properly consider persons with disabilities in the city emergency plans. In a similar suit in New York, that actually went to a jury trial, but the holding was the same, that the city hadn't adequately prepared for persons with disabilities. And this was both in their evacuation plans, their evacuation messaging, as well as their sheltering plans. And then a lawsuit very similar by the same rights advocacy group was filed against the District of Columbia in 2014. We haven't seen what the final disposition of that case is yet, but the allegations were the same. And it was that these organizations, when they're doing emergency response planning, they actually have to take specific pains to make sure that they are preparing for and considering what special reasonable accommodations should be made for persons who have disabilities. The assumption that someone who has a disability can just be treated like any other member of the public would be wrong, and that's what these cases have demonstrated, that you have to make reasonable accommodations lest feel the burden of a similar lawsuit being filed against your organization. Now, there were also two cases that came out of Hurricane Katrina that can demonstrate how liability allegations from a disaster response can be levied against a healthcare provider. The two that I'm going to talk about are Husband v. Tenet Health Systems and Mineo v. Underwriters at Lloyd's. And these both demonstrate that liability can be alleged by not just the patients that the healthcare facility is serving, but also the employees and members of the public. So the first case, this is a situation that many of you may be familiar with. This has been on the news. There's been a lot of books written about Memorial Medical Center. And Memorial Medical Center was hit just like the rest of the city of New Orleans pretty hard by Hurricane Katrina, and that resulted in a lot of flooding and power loss. After the storm had passed and the full extent of the damage was known, patients, family members, visitors, and staff and employees of the hospital all brought a class action suit against the hospital for damages stemming from the evacuation and the failure to evacuate. So the allegations were wrongful death, injury, property damage, all of the above. And for the non-attorneys, a class action lawsuit is when you have a group of individuals who, even though their disposition as far as the hospital is concerned is different, a patient is different from an employee of the hospital, that they all suffered a similar harm, a similar enough harm, and there's enough of them that they are able to join together as one group of plaintiffs and together sue an entity. In this case, it was the hospital. So these are patients, family members of patients who were visiting, but also family members of patients who had passed away or were injured, as well as employees, staff, visitors, people who were just on campus who suffered a harm during Hurricane Katrina at Memorial Medical Center. They all joined together and filed a lawsuit. And so the hospital challenged that class, saying these are all different individuals. This shouldn't be certified as a class. They shouldn't be able to join together and sue me, the hospital. But the Fourth Circuit Court of Appeals for Louisiana disagreed. And they felt that the plaintiffs had enough, two really important aspects to their case, commonality and typicality. They found that the individuals all had a common enough claim. Their allegation was that the hospital had been negligent in the design, inspection, and maintenance of the backup electrical systems, that they had failed to plan and improperly carry out their plan for evacuation. And since they were all on the hospital's campus at the same time, and they all suffered the same harms, that their claims were common enough that they could join together as a class, even though they were patients, employees, and visitors alike. And it was the same holding when it came to typicality as well. The theories that they were alleging negligence under came from the same event, Hurricane Katrina, a single large-scale disaster, and that provided enough justification that all of these individuals could join together and sue the hospital as a class. One of the issues we have, though, when we discuss case law is that we can only really go by our published cases that we can find, with our research services. When the case settles out of court, we don't really get a lot of that information. So as far as the kind of the life of this case went, this is where it ended as far as published cases goes. And so we know that this class was able to be certified, and then chances are they settled out of court after the fact. But it's still very significant that we have cases in state law where it doesn't matter if you're an employee or a patient. If you suffer a harm as a result of a big disaster like Hurricane Katrina, where everyone was kind of touched equally by the allegations against the hospital, that there is some precedent for the class being certified, and you can join together and sue the hospital. Now, the next case I want to discuss is a little bit different. This actually came as a result of some injuries that were sustained by a patient at a nursing home in Louisiana. Another Hurricane Katrina suit, but it was the children of a nursing home resident who passed away after he was not evacuated during Hurricane Katrina. And they filed a negligence action against the nursing home, saying that it failed to provide adequate food, hydration, and medical care to the resident. Now, the reason this case kind of came before this high court in New Orleans is because Louisiana, like a lot of other states, have a specific system for medical malpractice suits. Before you can file a suit in civil court, you have to exhaust all your other remedies, and that includes going before a medical review board. And so the nursing home was alleging that this case shouldn't be heard by the court because this all involved medical malpractice, and it should go before that review board instead. And there were a number of allegations that the children of this deceased patient were alleging against the nursing home, including, like you can see, medical care, but also failing to provide adequate food and hydration, proper electricity, air conditioning, and things like that for the individual. And so while the judge found that the medical claims, that the treatment, failure to provide prescriptions, and health care, those really typical health care services that nursing homes can provide, those definitely should have been heard by the medical malpractice review board. The other aspects of it, so providing air conditioning, providing food and water, those really basic necessities, those didn't actually sound in medical malpractice. That the nursing home, outside of its duty to provide medical care, had a duty to provide those basic, those basic services to the nursing home patient. And so the case was able to continue with respect to those specific claims. And it also provided a really interesting note when it came to evacuation. The court stated that as far as the allegation that the nursing home had failed to notify the tour bus company who was providing evacuation services that they were needed to transport the patient out of the nursing home and out of New Orleans, and the failure to comply with notifying the tour company per the contract that was had with the tour bus company, could not be dismissed because there had to be a specific investigation and looking at the facts in the case to determine whether a city or state evacuation order can create a duty on behalf of the nursing home to safely evacuate its patients. So while the patient was there, they had to provide certain services, electricity, food and water, and also there was the question of whether an evacuation order also creates a duty to evacuate on the part of the nursing home. And so those allegations could not be dismissed. So again, like with the previous case, that's kind of where the life of these cases ends as far as published case law that we can find online and publicly available. But it brings them some really interesting points and serves to demonstrate that healthcare facilities really need to understand what legal duties they owe, not just to their patients, but also visitors on the hospital grounds, as well as their employees when it comes to preparing for and responding to emergencies. And there's one last case I want to talk about really briefly. This is Prince v. Waters, and this is a really interesting case. A widow of a volunteer firefighter sued the county and volunteer fire department after her husband was killed in the line of duty. And her allegations included the allegation that the fire department had failed to properly follow the incident command system. And I'm sure many of you who are on this call are familiar with the incident command system. It provides, a standard response system, delineates certain responsibilities and span of control for people involved in the response leadership. And it can be scaled to something as small as responding to an individual fire or as large as something like Hurricane Katrina, or if you look at the incident command system for the Gulf oil spill, it's a massive organization. But the incident command system can be scaled to those aspects. And what the court in this case found was that because the state had issued a directive saying that firefighters have to use the incident command system because it's a recognized, good best practice that they all should be following, that the incident command system was formed what's known as the predicate for liability under state law. So it mandated a reasonably defined and precedentially developed standard of care, and didn't require the judge to second-guess firefighters' split-second weighing of choices of how to do command and control in response to a fire. And so since the incident command system had been adopted as the standard for responding to emergencies in the state, that could be used to identify liability. And so since we know that, now we know of an example of a case where the incident command system can be used to identify whether a hospital, in the case for the attendees on this, or in this instance with this case it was a fire department, whether they were improper in responding to emergency. We can look to the incident command system and whether it was followed to help make that decision. So it's a really interesting case to kind of keep in mind and keep in the forefront of any conversations you might have with hospital leadership about the importance of preparing for emergencies and understanding the important role that law plays. So as far as law goes specifically, especially in my role working for the Centers for Disease Control and Prevention, it creates some really interesting, what I like to call intersection points between public health, those health departments who are providing services to both local, state, federal communities, and healthcare providers, those organizations that are charged with providing healthcare services to the public and to the patients. And these are really important intersection points because it forces, two very different branches of our health system to interact and provides for certain roles and responsibilities for either party. So I want to talk about kind of two important aspects of where this intersection can take place. We're going to talk about disease investigation, and then we're going to talk about isolation and quarantine authorities. So, to control the spread of diseases, health authorities have to determine who has been exposed. This is just a really basic thing that we all understand, we all can agree on. If we're going to fight the spread of disease in our communities, we have to know where it is, how it's spreading. But government agencies need an authority to be provided to them under the laws and regulations of their state. And so where do public health authorities get the power to investigate diseases? Well, state law. Here is an example of a Texas statute that provides the health department with the authority to investigate diseases. This authority can be very broad. Here in this Texas statute, it says that the state health department is given the power to investigate the existence of communicable disease in the state to determine the nature and extent of the disease and to formulate and evaluate the control measures used to protect public health. This is a very broad grant of authority. It also states that a person shall provide records and other information to the department on request according to the department's written instructions. And some of the people who work for health departments on the call, their ears might be perking up in terms of privacy issues, and I promise we are certainly going to get to that in a little bit. But here you can see a really broad grant of authority to investigate diseases, and then also this requirement that a person, very broad, a person, however that's defined in Texas statute, has to provide records according to the department's written instructions. And this power to investigate can also come with really broad implementation authorities. So the statute also provides that the Commissioner of Health or an employee of the health department or a health authority, which will include local health authorities, has the right of entry on land, in a building, vehicle, watercraft, or aircraft, and the right of access to an individual, animal, or object that is in isolation, detention, restriction, or quarantine. So this is a really broad power to enter a premises to investigate the spread of diseases and have access to individuals that are subject to that investigation. Now, to investigate diseases, sometimes that might require mandatory testing, and we can see really broad statutes and authorities that are provided to health departments to require the testing of an individual. So here's a statute from Kansas, and it says the Secretary of Health is authorized to issue an order and adopt rules and regulations as may be medically necessary. So this is a really key point here. It has to be medically necessary. You have to be able to justify that what the health department is doing is necessary to protect the public's health and well-being, and reasonable. That there's reasonable meaning that there's no less restrictive alternative that exists. That it's reasonable that we're going to require testing, and that it's to prevent the spread and dissemination of dangerous diseases that are injurious to the public health, including but not limited to provided for the testing of such diseases. Now this is a broad power, and it's definitely going to come with a lot of considerations, due process. We're going to talk to that, especially with regard to quarantine and isolation. But we can see this power being provided to health departments to require testing. And this is a kind of a loaded authority, because who's going to be conducting the testing? Is it going to be the health department? Is it going to be a healthcare provider where an individual is being held under quarantine, or perhaps just being treated where they're refusing to be tested, but the health authority needs to require testing. Some states, this mandatory testing can only come if it comes with an order from a judge. In others, it can just be the commissioner's order that is required for mandatory testing. It's really going to fall to the laws of the jurisdiction where this is taking place, and it's really important for not just those health authorities who are working for the health department to know what those authorities are, but it's important for healthcare providers too, because if a health department comes and is requiring a certain action, and they're saying that they have the authority to do so, it's helpful for those healthcare providers to also be familiar with those authorities and how they have to be carried out. So the power to investigate disease can also come with the power to obtain specific health information. Here is a required disclosure law from Maryland, and it says that the Secretary of Health, through either an individual order or through regulations, can require a healthcare provider or other person to report information to either the Secretary or a public health official. The Secretary also has the power to obtain access to information that's in possession of a healthcare provider. So information that's held by the healthcare provider, the Secretary actually has access to it, and also can require or authorize a healthcare provider to disclose information to an agency of either the federal government, the state or local government, or to another healthcare provider within the jurisdiction. So this is a really interesting authority given in Maryland, and to provide access to information that is needed to protect the public's health when there's a possible disease outbreak. And going back to Kansas, this is a prescriptive requirement, a broad requirement that whenever a healthcare provider, social worker, or teacher knows or has information indicating that a person is suffering from or has died from a reportable infectious or contagious disease, and that's often defined in statute, what constitutes a reportable infectious or contagious disease, that information shall be reported immediately to the county or joint Board of Health or to a local health officer. So this is an affirmative requirement that a healthcare provider, social worker, or teacher has to provide and report this information to the local health department. So, as promised, what does this all have to do with privacy protections? We're taught, that our health information is private, it has to be protected, that there's a specific HIPAA privacy rule, there's a specific HIPAA security rule to make sure that the information that I own as a patient that's being held by a healthcare provider is going to be protected. And that is true, that is absolutely true. But there are some limited exceptions to the HIPAA privacy rule. And one of those exceptions is uses and disclosures for which an authorization or opportunity to agree or object is not required. So when is it not required for me as a patient to give you specific permission to release my information? And one of those exceptions is when a public health authority that is authorized by law to collect or receive such information for the purpose of preventing or controlling diseases, including but not limited to reporting of the disease, they conduct public health surveillance, public health investigations, and public health interventions. So all of those state statutes that I just described on those previous slides, those are all those state laws, those legal authorizations to collect and receive the information that as it's being described here in the HIPAA privacy rule exception. So an exception does exist under the HIPAA privacy rule. Now, that doesn't mean that these pieces of information that are being provided to health departments are unprotected, that we lose the protection that we as individuals have over our health information. A lot of these laws that require reporting to health departments also come with specific protections that attach to those reportings. Here's a statute from Virginia. It says that a reportable disease report that's submitted to the health department is confidential and is not considered a public record pursuant to the Freedom of Information Act within the state. So while the Department of Health can share information with other health agencies such as the CDC and state and federal law enforcement agencies, this information is still protected. It still has to be kept confidential. It can only be used within those organizations for the purpose of investigating a disease. Additionally, the Commissioner of Health is charged with preserving the anonymity of each patient and practitioner whose records are examined pursuant to this authority. So the Commissioner has to protect it, but he's also given the authority under his or her discretion to divulge the identity of patients and practitioners if it's pertinent to an investigation, research, or study. And if the information is going to be provided, it will be up to the Commissioner to show that it's justified, that identity had to be divulged, that there was no other alternative to preserve that person's anonymity. So the next kind of intersection point between healthcare and public health that I want to discuss is in the control of movement. The power to control the movement of individuals has been recognized as within what are known as the police powers of state and local health authorities. That's provided by the 10th Amendment of the Constitution. But these measures can take different forms, and they come with a lot of rules and limitations. But first, let's get some definitions out of the way. There's a big difference, and a lot of times it gets mixed up between what's isolation and what's quarantine. Isolation refers to the separation of persons who have a specific illness, infectious illness, from those who are healthy, and the restriction of their movement to stop the spread of that illness. So by definition, isolation is separating sick people who we know have a contagious disease from other people who are not sick. Now this is very different than quarantine. Quarantine refers to the separation and restriction of persons who, while not yet ill, have been exposed to an infectious agent and therefore may become infectious. So quarantine separates someone who may be sick, that you have a reasonable belief that was exposed to a contagious disease, but you don't know specifically that they are infected, from those who you are reasonably certain have not been exposed. And this is a really important distinction when it comes to justifying those actions. Isolation, by definition, is separating someone who you know is sick, someone who you have a disease. And chances are that person might be exhibiting symptoms, they might feel ill, and really want to receive healthcare treatment. Quarantine, on the other hand, can be a lot more difficult because by definition, those individuals feel perfectly healthy. They feel fine. There's no confirmation that they have a specific illness. And so you're going to have to show through either their history, through their movement, through their interactions, that they were exposed to a disease if you're going to want to justify quarantining an individual. And we have to kind of provide these specific definitional differences because we see all the time in academia and in the media, they're used interchangeably, and that is just not the case. They are very distinct authorities. So quarantine and isolation, they restrict the personal liberty of an individual at their most fundamental nature. And many state and health laws don't spell out what all of the procedural requirements are for quarantine and isolation, while others have really fairly detailed provisions. But regardless of whether they're really specific in the procedures or very broad, these protections are derived from the constitutional due process requirements that are triggered when the government is requiring someone to be deprived of their individual liberty. And in this instance, it would be the liberty of movement, the liberty to move freely. And due process requires notice and hearing. It also requires showing that the detention is necessary to protect the public's health. And the individuals provided a right to counsel, a right to have an attorney represent them if they're challenging an isolation or quarantine order. And so the Fifth Amendment provides that the federal government has to provide due process when someone is deprived of life, liberty, or property. And the 14th Amendment also provides a due process requirement on behalf of the state governments. So let's see how this can impact healthcare providers. In Texas, we have a really interesting statute where it says that a health authority, so a healthcare commissioner, the state health officer, someone charged with the duty of enforcing isolation or quarantine, can actually designate healthcare facilities within the health authority's jurisdiction that are capable of providing services for the quarantine, isolation, or imposition of control measures during a public health disaster or during an area quarantine. So this gives those public health professionals the ability to actually designate possibly your healthcare facility as the location of the quarantine. Now, this isn't just a broad everyday power, though. Note at the end of that first sentence, we see, can I actually draw here? Hope I don't mess up this whole system. We see during a public health disaster, trying to underline, not cross out, and during an area quarantine. So there are prerequisites that have to be met before this authority can be exercised. That a public health disaster or an area quarantine has to be established before this health authority can actually designate a healthcare facility as a location of quarantine or isolation. But this authority does exist according to the statute, and there may be similar authorities provided to other states through other either specific grants of powers such as this, or through broad isolation and quarantine authorities that are being provided. So as you can see, there are a lot of really interesting ways in which healthcare and public health can interact. We created a great website to provide a lot of the wonderful resources that have been developed by all the great organizations out there as they relate to healthcare, hospitals, and legal preparedness, understanding the role of law when it comes to preparing for and responding to emergencies. So I included a link off to the side to this website. You can see it here below. And it's just a really great list of resources separated by topic area to kind of help you understand and give you tools to address legal issues when it comes to preparing for emergencies. And that concludes my presentation. Michael?
Good morning. My name is Michael Munda, and I am in charge of accreditation and regulatory compliance at our Renowned Health Network. I wanted to communicate to the audience today about how to create and, more importantly, maintain a defensible emergency management program in healthcare. So the first definition we need to address is, what is defensible? What does that mean? That means, simply put, that if you go into court, do you think you're going to win with what evidence of compliance that you have with all of the laws that Greg just talked about? And he did a great job, by the way, of spelling every type of law, the reasonable care, the duty of care, and those kind of attributes that are necessary for an emergency management program to be defensible in court. So as we all know, there's a very high duty of care associated with a common carrier in a healthcare setting, especially a hospital occupancy. And of late, the modern trend in healthcare and determining defects is to have a preoccupation with failure points. So we're not so much hung up or focused on actually patient harm, although we are, but an increasing number of resources are dedicated to focusing on the near misses, the potential for patient harm. So a lot of emergency management planning focuses on mitigation, planning, and preparation and practice. And one quote I'll use throughout this presentation is, Practice doesn't make perfection. Practice makes progress. So that's one of my key points in a defensible emergency management program. You have to evidence a continuing, recurring practice of mitigation and planning. So QAPI, what is it? QAPI is a CMS Medicare, Medicaid services term that requires medical facilities, healthcare occupancies to have a quality assurance and performance or process improvement process at their health network, at their hospital. What does this mean? This talks about flow of information. We've seen in emergency management that there's been an increase in leadership standards of the onus of responsibility on the governing board to ensure that all of the patients, all of the employees are safe. So when we're looking at care, treatment, and services for patients in an emergency, we want to make sure that all of our emergency management programs, our preparation, our mitigation, our write-ups and documentations of actual response and recovery operations are in the minutes of a meeting somewhere, and that could be in your environment of care meeting, could be in your quality assurance meetings. One thing we've done with success at Renown Health is embed our safety and our emergency management programs into our meetings that have traditionally been reserved for clinical metrics. So, for example, of course, there's ongoing data and trending going back on falls, on slips, on OSHA kind of things in the hospital. But has there been trending and reports for emergency management? Well, traditionally, no. But what we see with CMS requiring more quality assurance processes in the hospital, you should have your emergency management programs be reflected in those minutes. And I have more to tell you how to get your operations into a defensible mode. And most of it's practice and simple documentation. And I'll go through one case example of an airplane crash. So one thing I want you to walk away with today is, number one, communication is key. There's a national patient safety goal, obviously, that communication among caregivers is a priority. And we all know why. Because the more we talk and the more we collaborate and the more we move toward a common goal, the more the patients are safe. And that's what we're here for. So the other point is I want you to incorporate your emergency management and safety committees into the quality assurance functions at your hospital. So, for example, if you have an environment of care committee or a safety committee, which most hospitals do, you should make sure that that annual report at a minimum is included in perhaps your medical staff quality improvement, your medical executive committee meetings, or your board meeting, at least on an annual basis. That's key. That's the nexus or the connection between what's going on in operations and what's going on in governance. And as I said, the more all of these parties talk to each other, the more the patient is safe. So number one, I love this visual because it's about listening. If someone's talking and you're thinking about what you're going to say next, that's evidence that you're not listening. So you have to listen for an underlying commitment. And here's an example. Sometimes there'll be conflict or there'll be a heated discussion on certain issues within safety. Maybe one discipline or one team wants something another way and the other team wants it another way. Well, there has to be collaboration, there has to be listening, and there has to be a compromise. Why? Because we have to get it together and produce results and close loops. Why? Because if you're rolling into our hospital, like one of 37 patients who we received during an airplane crash, your systems and your processes and your relationships need to be smooth so we can operate at an intense pace. Discussion versus dialogue. I always like this visual that discussion is more like banging on a snare drum. And for those of you drummers out there, you know what I'm talking about. A little loud, maybe a little irritating. A dialogue is something that we need to involve listening with. So that's just some terms we use in our safety and emergency management programs that when we collaborate, we dialogue. We are all on the same team because our underlying commitment is the same. And some of the things that I'll share with you from our after-action reports, our general knowledge and increase in learning, is a tool. Just like the Pony Express, they had a certain process, a winning formula. This is what wins, I think, nationally and for Renown Health Network. So I'm going to give you a few. One thing, and you'll think it's so simple, but I hope it's somewhere in your documentation. And by the way, I'm a big advocate of concise, brief after-action reports. I remember many, many years ago, an emergency management manager told me that it takes him 6 months to complete an after-action report. Well, yes, if you had a detailed analysis, it could take up to 6 months. But one rule that we follow and that's been successful is we do an after-action report in 24 hours. It's out in print for everyone to see and everyone to collaborate on. So you have to define what an emergency is. Is that a reputation event? How are you going to screen what type of events that come through? Is it an actual harm or is it mitigation for harm? So define an emergency. Like I said, you have to show action. So the fact that you define an emergency, you took an action that someone with reasonable care in your position would take, right? Define an emergency. And you have to show that. There can't be an absence of documentation in your emergency management program. So I would say write everything down, keep it brief, and move on. And also another one of my favorite quotes is action cures fear. If you have a little trepidation about starting a program, you need to take the first step. And does that mean have a massive drill tomorrow with 20 different state agencies? Or does it mean you have a tabletop drill for 20 minutes with some members of certain units to identify some issues that you need to work on? Well, obviously it's the latter. You need to have a tabletop drill. The Joint Commission requires 2 major drills per year, essentially. And we find that if we conduct maybe 10 times that amount, 20 to 30 drills or real events, but we scale down the scope of each event, we have more success. And also, healthcare settings, since our high duty of care, we must focus on the actual knowledge we have. If we have knowledge that something's a risk to continued care, treatment, and services, or can possibly cause patient harm, we need to do something with that actual knowledge. If we think something might be out of whack or we need to prepare more, there's an opportunity for improvement, that's constructive knowledge that we need to act on. And again, whatever actions you take, imagine the worst calamity or even a minor calamity or tragedy in scale of volume of patients later on in any kind of suit that's going to be brought out in court over the steps that you take. And just a famous quote from Dr. Mark Chassin of the Joint Commission talking about high reliability, how there has to be effective process of improvement tools and widespread adoption. This goes back to incorporating your findings from your after-action reports into the general hospital program. You can't operate in a silo anymore. So one of the methods we use, which works, is applying lean methodologies. We use transformational healthcare, Toyota manufacturing principle, established by a founder of that system, Taiichi Ohno, who said without standards there cannot be improvement. One case review is that we had a quick, very small fire that was extinguished in probably 5-10 seconds in our French fryer with hot oil. Well, we conducted a full root cause analysis on that event, completed that root cause analysis in 1 hour. And from it, we changed practice. We changed position descriptions requiring certain additional training with fire extinguishers for certain additional workers. We took every potential, not that harm happened, every potential we hit on. We're more focusing on the near miss. You have to go one step in front of the harm to get toward that's true mitigation. And you need to write it up. If your after-action report's a paragraph, using the framework that the Joint Commission uses, communication, staff education, licensed independent practitioners. That's all in our emergency management standard framework. You're going to be okay if you have to defend it. And I'll have a few examples on some of our real events. In court, they're going to talk about what was the breach in the program. Did you not have the policies and procedures? Did you not have the education? My big message to you is to start practice today and to start on a very small scale. So it's easy to get policies and procedures. I can get paper immediately if I order some best practice policies. But to get education and training, you need to really list your top 3 education and training that you're providing your employees. And also, a few other examples. One example is there was a shooting in our local community several years ago. And you need to make sure your security task force has some goals. What are the metrics they follow? How are they improving performance? So you might think for security, and what I'm saying is metrics and performance improvement goals traditionally had or studied in the clinical realm, such as reduction of infections, increase in core measure compliance, are now being brought into the safety and emergency management world. So I'm not saying have 3,700 metrics. I'm saying focus on your top 3 per year. We might have 12, 15 goals for the year, but we'll focus on maybe 1 to 3, really focus for robust improvement. So if situations, I love this slide, something's obviously wrong here with this truck. At first you would think, well, how can someone be so unwise as to place themselves in harm? Well, we ask a different question in process improvement. We ask, what did we do to allow this defect to occur? So a much different focus. We're focusing on process and eliminating defects. How can we ensure that there's a system where that person would never be able to get under that truck to do some work? So we're focusing on defects. And I just wanted to tell you about, we have air races here in Reno. It's been around since 1964. I'm not going to read the slides to you, but it's a very, very large event. People come from all around the world, almost doubling our population in this area is approximately 400,000 folks here in northern Nevada. And they have all kinds of planes, different planes. And I wanted to talk a little bit about what happened that day. And I want you to use your imagination, because using your imagination is more important than knowledge, according to Einstein, and I totally agree. So if you had 50 patients come to your facility right now in a mass casualty, are you prepared? If you're not, focus on the top 3 things why you're not prepared. What is the root cause? Focus on those things with a multidisciplinary team for 2016 and come up with 3 sub-bullets under each of those 3 categories and show some improvement. So this is an example of what we did. This is a very orchestrated drill. Most of our drills are 30-minute to 60-minute drills. We have no dedicated budget for emergency management because we've embedded all of our emergency management and safety into our existing operations. So here's an example. We put on this drill with all county partners. By the way, we have a monthly meeting. We're a coalition, inter-hospital coordinating coalition, where we have county, state, city representatives in all hospitals in the area for a monthly meeting to talk about these things. Again, communication, right? The more we talk, the more my mother, my kids, my neighbors are safe when they roll into our trauma center. So this talked about a lot of rising stress in the world and how we have to have relationships. This is a picture of a land speed record, get rid of debris on the playing field of relationships. That means have a cup of coffee with your county emergency manager. Set up that meeting. Have a face-to-face meeting and talk about what are the top items for them. Because when things move fast, you have to make sure there's no debris on the playing field, there's no barriers, there's no attitude. It's all about continuing that care, treatment, and services for the patient. So we moved on and simulated, this is not real, we simulated that there was these events. We had mass events. And as I flip through these slides quickly, you'll see that we do have a crisis action team, and we considered all of these things. This is the doom and gloom, freeways down, with no ongoing supply of resources. Well, this was a year-long project, and we took a lot of time to determine the top 3 things. So I would say, what is your biggest event? For us, it was the Reno Air Races crash. And that day, one plane killed a number of people. We received 37 patients, and it was a hospital incident command system activation, obviously. And we had just practiced for an airplane crash several months before. But you know what? Every couple years, we practice for a plane crash along with other things. So my big point again, increase the scope of the number of items you prepare for, but reduce the time of the actual practice. You need to just get 1 or 2 distinctions in a 30-minute tabletop drill and jump on any opportunity for improvement identified, close the loop, embed it in policy and practice, and move on, because there's 20 behind it. So what is your biggest event in the area? If it's we have a hot air balloon races here in Reno. We have other events like the Reno Air Races. Talk to the organizer and see if you can conduct or attend a meeting and have a tabletop drill. What is that? That's asking a few questions about what if this, what if that, and writing it up. So there was also a train crash we had. How we prepared for that is communication. What happened is we had a first report that there was 220 patients about to come to our healthcare center. We only ended up getting 6 in our trauma center, and they weren't critical. But our communication, which is done by an automated system and overhead speakers, was immediate. So we had full trauma teams ready. So again, communication. We had a shooting in Carson City here. We didn't know if that was terrorist related, so we had our security control access. Controlling access is huge, and you should have backup vendors for that. With fires, no matter what the emergency is, you have to author your own hospital policy. Like I said, it's easy to get policies for evacuation, but to practice for 30 minutes with one unit and write it up in 30 minutes and identify one opportunity, that's authoring. You know, and here's it. I love this slide about if you bought a table versus you built a table. You really need to make it your own. So, of course, this is the framework we use, communications, resources, and our emergency operations plan. We have an administrator on call system, which I highly recommend, and this is kind of the special task force team that responds to any potential for threats of care, treatment, and services for a patient. I like to focus on mitigation and preparedness, and we always use volunteers, and like I said, it doesn't have to be really drawn out. Here's just some other examples: transformational healthcare, communication. One thing we did is we drew a line on the parking lot. This is an example of what is simple. When you have reporters during an event and they come into your hospital, we drew a line, a painted yellow line across the property line and said you cannot cross. That's simple. You know, genius is simplicity. We have a general role acronym for all staff in our new employee orientation, and we really focus on Family Assistance Center. Joint Commission has a lot of literature on that. So a number of items, of course, you're going to identify with any after action, but if you know the why we're doing it, you need to spread that why and everywhere you can for education and training. And that's just a list of some of the training we have. And again, you have the will to prepare to win must be stronger than the will to win. In other words, you have to focus on short practices or you will not achieve your goals. Cry in the dojo, laugh on the battlefield, an obvious exaggeration, but you really need to focus on mitigation and preparing with brief after-action reports, maybe even one page. and move forward. So that's my big message. Embellish it and incorporate it into your QAPI program.
Thank you, Greg, and thank you, Michael. That was a fantastic presentation. I think it gives us a lot to think about.
Thank you very much.
At this time, if you have questions,